It is 1:30. My name is Jordan Walker. We are going to go ahead and begin this webinar. Thanks for joining us this afternoon to talk about eminent domain, to talk about the SR20 connector project, also known as the Rome-Cartersville Development Corridor. With that being said, we're going to go ahead and get started. So again, my name is Jordan Walker. I'm an attorney with Seaver Walker Padgett Law Firm. That is our office address. We're located in Alpharetta, Georgia. That's my phone number, my direct number, and my email in case you have any questions after the presentation is done. So real quick, just a kind of an introduction, what we're doing today. First of all, as another introduction to our firm and who I am an eminent domain attorney licensed in the state of Georgia. Our firm, Seaver Walker Padgett, is an eminent domain only, landowner only law firm. So this is the only area of practice that our firm does eminent domain working for landowners, meaning not only do we only do eminent domain, we only represent landowners. We do not work for GDOT. We've never worked for GDOT. We've never worked for any governmental entity. We've only represented landowners. We have offices in addition to Georgia. We have our Indiana, Illinois, Ohio, North Carolina, Missouri, Texas offices. We also have done work across the country, really in any state you could think of. And it's all to say that we've learned quite a bit about eminent domain. We've seen all types of acquisitions, all types of takings. We've dealt with all sorts of types of takers of property, condemnors as they're referred to as. And because we've learned so much, we're able to educate landowners who are in your situation, who we believe will be affected by this project. Which leads me to my first bullet point. Why did you receive this letter? A lot of landowners ask themselves that. That's because, according to our research, all publicly available information, your property is one of the several properties that's going to be affected by this road project. So that is why we sent the letter. That's why you received it. And so we would expect that based on our research, at some point, if you haven't already, you're going to start hearing from GDOT about acquiring some portion of your property for this project. Again, we are not with GDOT. We like to stress that because a lot of people aren't sure when they receive our letters who we are, what we're doing. And today, we're going to be talking about the project. We're going to be talking about eminent domain law in the state of Georgia. We're talking about key points to just compensation also in the state of Georgia, what you're entitled to under the law when the DOT comes and wants your property. So real quick, a little bit about the project. Forgive me. Sorry, it's a little off. Thank you for bearing with me. So the SR20 connector, also known as the Rome-Cartersville Development Corridor, is a new highway connecting US 411 to I-75. New highways are big projects. They usually affect quite a bit of property, and they usually affect them quite negatively because they're new, as opposed to expansions on widenings. They kind of cut through all sorts of property parcels, and they cut through it usually in ways that are particularly impactful to properties. So that's a map there, as you can see to the east, demonstrating, or to the right rather, demonstrating the general path of this project. You can see to the left, what they are going to be installing, what they're going to be constructing. It's a 4-lane highway. They're going to be building 2 in each direction, shoulders. They're going to include a diamond interchange at I-75. You're going to have a median at various points of the project, intersections, of course, everything that you'd expect with a large project, a large new highway project. So that's the project right now. Our information indicates that they've begun right-of-way acquisition. They're at the beginning of right-of-way acquisition on this project. If you haven't received anything from the DOT, that's fine. That's to be expected. Like I said, we're at the beginning of right-of-way acquisition as we understand it. Of course, we don't work for the DOT, so we don't really have access to when they're acquiring, when they're not. We know they have begun at least issuing some offers to landowners. So I would expect that you, as a landowner that's likely affected, will receive an offer probably in the next year or so, next year to 2 years. The thing with DOT projects, as we found, is they kind of come and go, they ebb and flow. It's kind of a hurry up and stop situation. So it's very hard to predict when they're going to come in and make an offer. But we do know they have been making offers on this project. And we'll explain why that's not something to be worried about necessarily if you haven't heard any contact from them yet here in a bit. So what is eminent domain? It's a question we get a lot. An eminent domain is effectively the forced acquisition of your property for a public purpose. You can look at it as land seizure. Effectively, it's the government seizing private land and setting it to a public use. That's a very easy way of looking at it. So the DOT has the ability to effectively take your land, whether you like it or not. And they use the courts to take land ultimately if they need to. And when they use the courts to seize land, that is known as eminent domain. So that is effectively what eminent domain is. When they file an eminent domain lawsuit, it's called filing a condemnation lawsuit. So they have the ability to take it, but they still have to pay for it. It's not a situation where they take it and they give you nothing, or even give you what they think you're entitled to. You're entitled to just compensation for your property. And that is guaranteed to you by the Fifth Amendment, United States Constitution, and the Georgia Constitution as well. And again, GDOT has inherent eminent domain authority, meaning they have the ability as a matter of right to file a eminent domain lawsuit against you to take your property. And if they were to do that, it would be filing a petition, and we'll talk about the process here in a bit, but they'll file a petition in the county court where the property is located. So the eminent domain acquisition process in Georgia, is unique to other states. Every state has their own process for acquiring land. What do they need to do prior to taking it? Do they need to do anything? What are the steps? In Georgia, there is a specific set of rules that the DOT needs to follow prior to initiating eminent domain litigation. So it's not a situation where the DOT can just show up one day and say, here's your offer, take it or leave it, we're going to sue you tomorrow. It's not how it works. The first thing that they need to do, and they have to do, is they need to perform an appraisal inspection of the property. And that means an appraiser who is hired by the DOT will come out to your property and inspect the property. And not only do they need to inspect the property, but they need to allow you, the landowner, the opportunity to be present during that inspection. So at some point, you're probably going to receive a letter from the appraiser that says, hey, we're going to come out to your property on this date. You have the ability to be there if you'd like, and we're going to do the appraisal. So that's the first. When people get that letter, that means that you're going to get an offer probably in the next couple of months. Because that's the beginning of the appraisal, and the appraisal forms the basis of the offer that they eventually make. So they'll do the appraisal inspection. The appraiser will go back to GDOT. They'll do their appraisal, and then another person's going to come out, a right-of-way agent, and they're going to contact you to issue the offer that's based off the appraisal that was done. And not only are they required to issue this offer to you, the landowner, but they're also supposed to provide a meaningful summary of the appraisal that was done to the landowner. This is another requirement under Georgia law that they need to do prior to utilizing eminent domain. So they have to inspect it. They have to give you the opportunity to be present during the inspection. They have to give you an offer, and then they have to explain the offer or provide a meaningful summary of the appraisal or the offer itself. So after the offer has been issued, And let's say that the parties couldn't reach an agreement, and they talks broke down. What happens next? At that point, GDOT will file their condemnation lawsuit. I touched on this earlier, their eminent domain lawsuit. And I say condemnation. When I say condemnation, I'm not talking about blighted buildings, unsuitable living houses, the boarded up houses that are not sanitary, not, they pose a risk to public safety. That's a different type of condemnation that is separate and apart from this. Condemnation in this context means eminent domain. Condemnation is the process by which eminent domain is exercised. So they'll file a condemnation petition against you, the landowner, if you haven't reached a deal with them. They will serve you a copy of that condemnation petition. That's important because as soon as you are served that condemnation petition, you have exactly 30 days to respond to the petition. And you need to respond with what is referred to as a notice of appeal. And that notice of appeal basically serves the function of saying, you, the landowner, disagrees with the amount of compensation that the DOT has determined you're entitled to. So we talked about the appraisal and the offer. When they file their lawsuit, they will go to the court and say, we believe this amount to be the accurate amount of what you're entitled to, whatever the appraisal says. And it's up to you, the landowner, to file your notice of appeal within 30 days of receiving the condemnation petition, saying effectively, I disagree with that amount of money, and I am entitled to more than what the DOT has determined. And that is called a notice of appeal. If you don't file that within 30 days of service, your case is over effectively. And all you're entitled to at that point is exactly that amount the DOT determined in their appraisal. So it's imperative that if you receive the condemnation petition, that you file that notice of appeal if you disagree with the amount of compensation that the DOT is offering, because otherwise you run the risk of being stuck with whatever they offered initially. And then ultimately, you are entitled to a jury trial in condemnation matters in Georgia. So if the case continues on after the notice of appeal, if the case is not resolved at any point thereafter, then eventually the case will end up in front of a jury trial where you can present evidence on what you feel you're entitled to under the law. And the DOT can also present evidence as well. And the jury comes up with a verdict that they feel you're entitled to, and that is your compensation. That's beginning to end, soup to nuts explanation of condemnation procedure in Georgia from the beginning of the lawsuit to a jury verdict. So let's talk about compensation. You'll recall that I said that you're entitled to just compensation for your taking of your property. And I've divided the types of cases into two different types: partial takings, partial acquisitions, and total acquisitions, total takings. Partial acquisitions are, as you might imagine, acquisitions of property less than the entire amount. So if you have a 4-acre tract and they're only taking an acre of the property, that's a partial acquisition. If you have a 4-acre tract and they're taking the whole 4 acres, that's a total taking, total acquisition. These are areas of compensation where you are entitled to money under Georgia law. The first category, the first key to your case, so to speak, is the value of the acquisition. What is the land worth? And that's usually determined on a price per acre, price per square foot basis. And that is generally concluded based on looking at sales of comparable properties in the area. Also, you can set forth an argument for a higher and better use than what your property is currently used for. As an example, if your property is used residentially, but let's say the surrounding area is all commercial, and your property, were it to sell in the open market, it would sell commercially. You could then argue that the highest and best use of your parcel is commercial and not residential. You're also entitled to remainder damage on partial takings if you can demonstrate it and it exists. Remainder damage effectively means, how does the acquisition impact the remainder of the parcel? It can come in many different ways, many different causes or consequences of takings exist for remainder damage. These are just some examples. of residential and commercial remainder damage types. In residential case, the biggest remainder damage that we've seen is the loss of setback from the roadway. Generally, if the house is closer to a road, it loses value because generally people do not like to live near homes. So losing setback can often cause a significant reduction in the value of the home itself. And that goes along with ordinance noncompliance. If the road puts you out of compliance with setback rules for your city or county, that can cause an impact on value. The loss of tree buffer is another. Really, anything that will expose you to the roadway, a house, or expose the house to the roadway, or lose the buffer that you might have. Those are the largest causes of setback and remainder damage for homes. For commercial, it can also come in a number of different ways. Again, ordinance noncompliance, losing access is a big one. Lost visibility, reduced parking is a significant one that happens quite a bit. All of these are types of issues that can arise from takings on partial acquisitions of commercial properties. And then business losses. If you can demonstrate that your business on the property, that includes a landlord tenant, is going to be completely destroyed by the acquisition. So if you're going to lose the business entirely, you can demonstrate that, and you can demonstrate that the business can't be relocated to another property. You can potentially get business loss recovery for any business loss that's caused by the acquisition. Then for a total acquisition, again, this is when they're taking the entirety of the parcel. The business loss and the value stays the same. Those are the same components. You're still entitled to both if you can demonstrate them in total, just like in partial. The big difference is relocation benefits. And relocation benefits, again, for commercial or residential acquisitions where they require the relocation of a home or a business on the parcel, this is compensation you're entitled to in addition to the other components. So you would be entitled to the value of the acquisition. You'd be entitled to business losses such that exist. You'd also be entitled to relocation benefits. And relocation benefits effectively are what does it cost to relocate whatever's on the parcel. And for residential properties, you're entitled to moving expenses and a differential payment. And this is for the homeowner, not necessarily a tenant. The homeowner is entitled to moving expenses, that is picking up and moving your belongings somewhere else. And they're also entitled to a differential payment, which basically is the difference between the value in your home and the value of a similar home that's available on the market right now. So if your property is worth $300,000, but it would cost $400,000 to get into a similar home on the market as of the date of valuation, then you would be entitled to $100,000 in differential payment between the value of and that would be the difference again between the value of your home and a replacement home. And then for commercial properties, you're also entitled to moving expenses as well. But in addition to that, also reestablishment expenses. So any expenses you'd have to incur reestablishing the business somewhere else. Commercial properties are not entitled to differential payments like residential properties. Okay, now I want to talk about hiring attorneys because a lot of people don't that are faced with eminent domain don't have a lot of experience hiring counsel, hiring attorneys. So I want to talk about some general contractual relationships, arrangements between attorneys and landowners in eminent domain scenarios. The first most common type of contract or arrangement between landowners and attorneys it's called a contingency fee contract, contingency fee arrangement, where the attorney's fee is contingent on how much money or how much more they get, more money they get for the landowner. So if the attorney's fee is a third, for example, third over and above the offer, the attorney would collect 1/3 of any amounts they receive over and above the offer from GDOT. And that fee would come out at the end and it would be entirely based on how much more money the landowner or the attorney gets for the landowner. Most contingency fee agreements do not have upfront costs, do not have retainer fees, and generally there's no real money exchange between the parties until the case is resolved at the very end. And that's when the fee comes out for the attorney. And then there's also the hourly and billable rates, or these are more traditional attorney fee agreements, ones that landowners or people might be more familiar with, where the attorney basically bills for their time, the time they're working on the case, whether they're sending emails, phone calls, drafting pleadings, showing up at court, all of those things. Any work they do is billed to the client at the hourly rate that the attorney charges. A lot of times, this type of arrangement requires an upfront retainer, some amount of money that the attorney bills against. So, for example, if the attorney wanted a $5,000 retainer, $10,000 retainer, they'd ask for that up front from the landowner, and then say they bill at $500 an hour, they'd bill for every time they did something against that retainer. And then if the retainer runs out, the attorney might ask for a new retainer, or they might continue just to bill over and above the initial retainer. Um, Also, other agreements that exist, flat rates. Some attorneys generally will do a flat rate. Well, they'll charge some amount of money, no matter how much work is done, and they will get that paid generally up front. And now I will open up. That is the end of my presentation, and I will open up for questions if anyone has any. Um, that's my contact information. If you have any questions that maybe you think of later, go ahead and shoot me an email or give me a call if you'd like to ask me any questions that maybe you don't think of now. But if there are any questions you have, feel free to use the chat box or the Q&A option to go ahead and ask any questions you might have. Okay. I'm not seeing any questions, which is fine. If you think of your question later, again, don't hesitate to shoot me an email or give me a call. I'm happy to talk further about eminent domain if you'd like. That's my number. That's my email. Thank you for joining us this afternoon, and good luck with your eminent domain matter.